The Alabama Ethics Commission is now in order. I want to welcome all of you to the proceeding today. My name is Jerry Fielding. I am the chairman of the commission. It's my honor and pleasure to serve with this lady and these guys up here to my right and left, and I want to introduce you to them at this time. The gentleman right next to me is Mr. Butch Ellis on my right side. He is from Columbiana, a lawyer. The gentleman to my left is Judge Charles Price, a lawyer, but he's better known as Judge, retired. And to my far left is Ms. Beverly Brady, a lawyer from Auburn, Alabama. And to my far right is Mr. John Plunk, a lawyer from Athens, Alabama. There will be some procedures and processes we go through today, and I want to sort of give you the synopsis of that. We will start out with some advisory opinions. We have some motions to take up. We have some civil penalty appeals to take up and other matters on the agenda today, and these will be in open session. Then we'll move into a closed session, which is called an executive session, for two reasons, one of which is because we will discuss the good name and character of individuals involved under an exception to the Open Meetings Act, and two, because complaints, evidence, witnesses, and testimony before the commission are covered under the provisions of the Grand Jury Secrecy Act. After we get through with these discussions, we'll come back into open session and make our votes relative to those particular things we take up. We may hear one case or several cases while we are in executive session. If anyone is here to be heard concerning any matter on the agenda today, I would appreciate very much if you come up and sign at this table in front of me. We request that anyone that has a cell phone, and I suspect all of you do, that you just cut it on vibrate or cut it off, whatever would be convenient for you. At this time, I want to recognize Dr. Jeremy Pridgen, who is the senior minister of the First United Methodist Church, Montgomery, Alabama, who will give you our invitation. Dr. Pridgen.
Let us pray. Almighty God, in this holy day, in these holy season, we're grateful for your presence with us. We cannot envision a world where we would be left to our own desires, given our propensity to go our own way. Brother, you've revealed your nature to us and called us to seek your ways, to be just, to be whole, to seek humility, to be compassionate, caring, and kind. From among your people, you call forth leaders. We're grateful for all who serve and lead our great state of Alabama. And yet temptations can befall leaders, and we know all too well from our history that those who lead must also be watched over and loved. The trust they hold is a sacred trust. Good governance is built upon that trust. So today we pray for this commission. Ethics are the very moral principles that govern our behavior. And we would ask that by your power and your wisdom we would be led to conduct our affairs in ways that more closely reflect your nature. Give this commission your direction as they make decisions as part of their charge. May their work restore confidence for the people of this state and their government. Cynicism can erode a sense of hope among people, particularly in moments where that which may be legal is not necessarily right. We know this all too well from our past, and we would ask forgiveness that we might start a new and right and just path that would lead to a brighter future for all. This season where hope and peace and joy and love are found, help us to embody these things in our lives. And we thank you for this gathering as they serve today, that they might be channels of your goodness as we seek a just society and a holy world. Amen.
Amen. Thank you, Dr. Pridgen. And before you leave, I want you to give special attention to my son-in-law, Joe Sewell Moore, and my daughter, Amanda, when you go back to the church.
Absolutely.
Okay, they need special attention now. Under the old business, we'll be taking up the minutes from the October 3rd, 2018 meeting.
Move that we approve.
Motion made by Mr. John to approve and seconded by Mr. Butch. All in favor say aye. Aye. Anyone opposed? The minutes are approved. We'll move into new business now, and What we'll be taking up will be advisory opinions, but the first thing we take up in the advisory opinion is relating to an advisory opinion 2018-11 that the Secretary of State and also the Office of Attorney General has asked us to reconsider. And would there be someone here from the Secretary of State and also from the Attorney General's office that would like to speak to this advisory opinion? Okay. Just come on up, and I think it'd be appropriate for y'all to just stand at the table there and explain to these learned folks up here at this bench why we need to look at that thing again.
Sure. This is my first time appearing in this forum. Does one sit down or does one stand?
You just stand up, be
All right.
comfortable.
All right, so my name's Andrew Brasher. I'm at the Alabama Attorney General's office, and I was asked to come just to kind of explain to you why we moved to reconsider this opinion and what our issues are with the opinion. So first, I know that everybody in the commission understands and knows this already, but the number of offenses is relevant for two reasons right under the Campaign Finance Act. The first is for the question of the civil violations that this commission would impose penalties on, right? So the number of violations, the number of offenses is relevant because a first offense gets a lower civil penalty.
Would you back up and just
Yes, sir.
explain for everybody's benefit that might not know what we're talking about?
Right, sure.
What the advisory opinion says and how it impacts the Attorney General's office. I know the Secretary of State is very familiar with it. He was over here when we adopted it. So go ahead.
Sure. So the way we understand the opinion is that it says that the Ethics Commission, this body, has the authority to reduce the number of civil offenses attributed to a political action committee. And so that language is actually a quote from the opinion. It says that the commission, quote, may reduce the number of civil offenses attributed to a political action committee, unquote. And as I was saying, the number of civil offenses, and these would be reporting violations under the Campaign Practices Act, things like that. The number of offenses is relevant for two reasons. First, for this body, because you impose civil penalties on those offenses, and there's a graduated scale where a first offense gets a lower civil penalty than a subsequent offense. The other reason the number of offenses is relevant under the code is that in a criminal prosecution for a violation of the Fair Campaign Practices Act, there is a presumption of intent that applies in that criminal prosecution of an intent to violate the act if there's been a previous offense, right? So the way that works in a criminal prosecution, the way it's supposed to work, is that if there's been a previous offense, then the state in that prosecution could say, you know, there's a presumption that you intended to violate the act in this second, third, fourth offense because you already violated it before. So those are the two areas in which the number of offenses matter. And I guess I should step back a little bit further and say, if there is a violation of the Fair Campaign Practices Act, that is both a civil issue that comes to this body to impose a penalty, a civil penalty, but it's also a Class A misdemeanor that the state can prosecute. So in each circumstance, there is no sort of exception to the Class A misdemeanor part of it. Now, we have not prosecuted one of these in the past, but that's the way it works. So at the same time it's a civil penalty for this body, it's also a Class A misdemeanor that can be prosecuted. And the way the number of offenses works is it's relevant to this body because it shows the graduated penalties that are imposed, but it's relevant to the prosecutors because of that presumption that applies. Now, this is what this body held in the opinion that we're talking about, that this body may, quote, reduce the number of civil offenses attributed to a political action committee. And so we have basically two issues with that holding from this body's opinion. The first is that it seems to be saying that this body can pardon offenses or make it as if the offenses go away. Well, there's no authority for this body to sort of make an offense go away because, as I said, an offense is prosecutable as a Class A misdemeanor at the same time that it's coming up to this body to impose a civil penalty. This body's authority is to reduce civil penalties, to evaluate what kind of civil penalty needs to be imposed on a particular offense. But there's no authority for this body to pardon an offense or to make it as if it never happened, right? And so if that is what the opinion is holding, we would suggest that that is wrong because this body simply doesn't have the authority to make the offense go away. Each offense can be prosecuted as a Class A misdemeanor. This body is limited to reducing civil penalties that might apply to the offense. So that's point one. Point two, and the reason I say it seems the opinion held that this body has the authority to pardon, instead of that actually held that, is because we are frankly confused as to what the import of the opinion is. The opinion speaks about the civil penalty authority of this body. It talks about how this body can reduce the dollar amount of civil penalties, but then the conclusions that it draws and the question that is answering is not about the dollar amount of the civil penalties that are imposed. It's about the number of offenses, which, like I said, is a completely separate issue that would affect the Attorney General's authority to prosecute a criminal violation as a Class A misdemeanor. And so we see this language in the opinion where the opinion talks about this body's authority over reducing civil penalties, but the conclusions it keeps drawing is about the number of offenses and reducing the number of offenses. And so those are two separate subjects. So when we previously were looking at a draft of this opinion, let's just say we've had a very good working relationship with Tom and Cynthia, and they sent us a draft of the opinion to evaluate. Our first take from the draft of the opinion is that we literally did not know what the point of the opinion was because the language that was used about civil penalties is inconsistent with the conclusions that are drawn about the number of offenses. And so, for example, I'll just give you an example. The opinion, the final opinion, has this line in it. It says, quote, "Any reduction of a penalty by the Ethics Commission shall not impede the independent prosecutorial authority of the District Attorney or the Attorney General." We completely agree with that. But the opinion isn't about reducing the penalties. The opinion is about eliminating or pardoning or reducing the number of offenses. So even the part of the opinion that is recognizing the Attorney General's authority to prosecute doesn't talk in terms of number of offenses. It's talking about the civil penalty issue. And so that's, you know, I'm happy to answer any questions, I guess I should say, and talk about this further. But we have just 2 points. One, we just think this committee doesn't have the ability to pardon underlying conduct. And then 2, we're frankly not sure that that's even what you meant to say in the opinion, and we think the opinion itself should probably be clarified so that there's not this confusion about whether we're talking about civil penalties or the number of offenses.
At what point in time does it become a felony?
I believe these are all Class A misdemeanors.
I know they are, but
Right.
isn't there something in the law that would allow for at some point in time, and when you get so many of those, that you could be prosecuted?
I'm thinking no, sir. So I think what you're going at is each of these is a Class A misdemeanor that will be prosecuted as a Class A misdemeanor.
Yeah.
After a first offense, then there's that presumption of intent in the prosecution, but you're still prosecuting as a Class A misdemeanor. So there is no, so it's not as if it's, there, I mean, there's other parts of the act where it's graduated, where first offenses can become felonies or that kind of thing. This is really, it's always a Class A misdemeanor. The number of offenses for purposes of prosecution is really only relevant to getting this presumption of intent.
Any questions, Mr. Gentleman?
Well, Andrew, if you had a series of violations that were admittedly mistaken, they didn't know they had to file, and they missed three filings. Who makes that decision of whether you're going to prosecute that person criminally when it's plainly obvious they had no criminal intent? Who makes that decision? You want to make that, the Attorney General would make that rather than have the Ethics Committee make it.
Right. Ultimately, the Attorney General and the District Attorney would make that decision, and that's my point, is that the way this statute sets it up is each offense is both a civil offense that comes to this commission, but it's also a criminal offense. And so one reason why that makes sense, that you would have that split, is that the Attorney General may well have information that you would not have, right? So I mean, you could see clearly a reporting offense, that's on the face of the reportings, that comes to you, you impose a $100 fine or something, because all you see is that there's that reporting violation. While the Attorney General may have a grand jury investigating that person and see all sorts of other offenses that are related to that reporting violation.
But if you didn't, aren't you saying that then you would have the power to pardon, where the Ethics Commission would not have the power to pardon? Is that basically what we're saying?
We would
What
not
we're doing
be,
is pardoning.
we would just be declining to prosecute, right? So I mean, that would happen obviously in many situations where for whatever reason, through an exercise of prosecutorial discretion, the Attorney General and the VA would decline to prosecute. And once again, we're talking about Class A misdemeanors, not felonies. So, you know, I think that would be a routine call in a situation like the one that you just gave us. And just to be clear on that too, there's no question that this commission could say, well, this was an accident, these people shouldn't have a $10,000 fine imposed on them, we're reducing the fine. No question. That's what this commission's authority clearly is. Our point is just, we don't believe the commission can, and maybe didn't even mean to in this opinion, claim for itself the authority to say that the offense never occurred. And that's our real issue.
Okay.
Judge, I have a
Oh, go
question
ahead.
before we move on. Mr. Bradshaw, thanks for being here. We appreciate you sharing your thoughts on this. But how does this opinion affect the Attorney General's ability to prosecute? I noted you said the Attorney General has not prosecuted any case. So is there an opposition of prosecution of these cases? Is there a standard you're looking for?
You know, I guess I can't really get into the details of that. I would say we're concerned that this opinion would affect the Attorney General to prosecute in two ways. The first is that if this body did sort of attempt to pardon someone, right, and say not only that we're reducing the penalty for the offenses, but the offenses never existed at all, we would think that that would be sort of equivalently telling prosecutors that the offenses never happened, even if there was evidence that the offenses did happen, right? So there's that issue. That hasn't happened yet, but we read the opinion as suggesting that that is what you're saying you have the power to do. And then I guess the second issue is just, goes back to the confusion inherent in what we see the opinion is frankly confusing to us, and we believe it would be confusing to judges and confusing to others as to what it would mean if, for example, this body reduced a civil penalty. And so that would just sort of inherently make it difficult for us to prosecute.
Correct me if I'm wrong, does the opinion say anywhere that we have pardoned anyone for any failure to file or violation or whatever it is?
No, this is an advisory opinion, so all it says is that you have the power, you're asserting the authority to, quote, reduce the number of civil offenses attributed to a political action committee. So, and that's where it goes to. There's no question you could reduce a civil penalty, right, the dollar amount that someone has to pay, but reducing the number of civil offenses, it appears to us, and it appears to, I think, other reasonable observers, that you're claiming the authority to eliminate the offenses as if they never existed, as opposed to reducing the penalty that would attach to an offense.
Okay, but it doesn't say that it eliminates, does it?
It does not use the word pardon, no ma'am, and it also does not say that there's any specific offense that you have eliminated. It just is about the authority to eliminate that in some future case.
Thank you, sir.
You're basically saying that they're already convicted of the crime when it comes to us, and that our only responsibility is to set the amount of the fine.
Well, I guess I wouldn't use convicted of the crime, obviously, because.
But I choose to. But.
Okay. Well, we were talking about civil penalties, right? So these are reporting violations. What this body has jurisdiction over is reporting violations that are apparent from the face of the reports, right? These are things where the reports aren't filed on time, things like that. So it would come to you, and then the only question is what would be the civil penalty that should be imposed on that. And once again, it's clear under the statute, you could say 0 should be the penalty that should be imposed on this, because we don't think this is something that should be penalized. You absolutely have that authority.
If this commission doesn't resolve the issue like we've done it, you're gonna have people, like say misdemeanors. Some of these cases are 8 or 10 filing problems. I mean, they just didn't get them in. You know, up to a year in county jail. I mean, it's a pretty serious offense.
Right.
they're gonna be pending out there forever.
Well, with respect to any other class, I mean, it would be the same as with any other class A misdemeanor, in that it would be up to the prosecuting authority to determine whether it would be appropriate to prosecute that offense. And then also, of course, there's a statute of limitations that would run.
It would end at some point in time, but, it creates a problem for the particular individuals. Most of these folks are good, solid Alabamians, and they didn't have any intent to do anything wrong, but the filing requirements they're under, and electronics and so forth,
And to be clear, I get your point. To be clear, in any prosecution, there would be, the question of intent would be there, right? So one reason why a reasonable prosecutor would decline to prosecute someone would be the absence of any evidence of intent, right? So that would be something that someone would look at in determining to decline to prosecute these matters.
Okay, go ahead. Would you state your name and the record, please?
Good morning, I'm Brent Bill from Secretary of State's office. I won't belabor our feeling. I was here last time, certainly presented those, and would echo those. And you certainly have our letter asking for reconsideration. I will provide to you a little bit of background information. Commissioner Ellis had asked as far as what a prosecutor might do. The code says that we shall notify the DA and the AG's office on a fourth or subsequent penalty about a violation offense. And we do that. We regularly send letters to DAs and the Attorney General's office on those. So usually when a DA's office receives that, they'll contact us and they'll say, hey, can you tell me more about this person, or what happened here, and should I go forward with this, and looking at for more information. And we provide that information. Now, there has been no prosecution for this, as Commissioner Brady had asked, but I would say that this is the first year and first election cycle that we've really had this. So I can't really envision what local DAs or the Attorney General's office may do in the future with more information. Similarly to this commission, how y'all looked at it and said, look, this is a new law, new things are going in. I think they've used their discretion to say, look, maybe we shouldn't go forward with these because this is a new law, that we shouldn't prosecute folks for violating these things. But as we go forward and more information is gleaned, maybe multiple election cycles, a candidate that would have a history of violating these things, and it was shown to be, you could show an intentional act through multiple instances, then I think that would be up to the local district attorney or the Attorney General's office whether they want to proceed with that misdemeanor charge. So it's just as this commission certainly knows, it's a new law that we've all been trying to figure out and grapple with from the process. Now, what we also deal with regularly, and I think this may come up later today, kind of a foreshadowing, is we deal with folks where we send letters to folks and we say, well, look, this is your fourth, fifth offense. Well, they'll contact us and they'll say, look, I listed this as an expenditure, but it's not really an expenditure. Like, for example, a PAC would have administrative expenses where they're not really intended to influence an election, but they're there. So they list it as an expenditure, and we don't know really what those expenditures are, looking past facially the limited information they give us. But they provide us more information and say, look, this was not to intend to influence an election. This is just a bookkeeper, or this was just, different things that we're doing behind the scenes, paying for dinner, lunch, those type of things for the PAC. And so we've looked at that, and our offices took that information in and said, look, okay, based on the information that you provided us, you should have not been filing up until maybe the date moved that you crossed the threshold. So therefore, we would reissue a new letter to that person, and we would say, hey, this is your first offense, so it's not the fourth. But we would have already sent the fourth letter to the Attorney General and the DA's office upon notification of the fourth. And then that's how that works. So if this commission had the authority to set aside, we would also be sending out multiple letters after the fact saying, well, I know we notified you that they had violated 4 offenses. You would now be at 1, or you would now be at 2. So it gets into this complicated scenario of sending information to DAs, and really we don't have the authority to decide who gets prosecuted or anything like that either. And so it's really up to the local DAs to use the discretion and review the facts. And so that's for those reasons we would just ask that you reconsider this opinion. I won't belabor it. I would echo that Chairman Fielding had said last time, said usually when we do something the AG's office doesn't like, they typically come. And so I'm glad to have them here.
That was when they didn't show up last time.
They're here today though, Chairman, so, but that's all we have.
This is the last thing I'll say about it. I remember one of these multiple offenses we had. If I'm correct, I may be wrong about this, and I'll stand to be correct. It involved $2.81. $2.81. I believe that was the bottom line. Well, I said, what in the world are we doing here, putting somebody in a position where they be prosecuted criminal or a $2.81 deal? It just didn't make any sense to me. Somebody needs to look at it, and I'd say the first one that gets an opportunity to look at it needs to look at it and say, hey, this doesn't make any sense. That's just the way I feel. That's me personally.
Yes, sir, and that $2, I know you understand, it's 10% of your expenditures and contributions, and they had $20 apparently that they spent. I get it, I understand.
$2, and we got them up here, they gotta come, gotta get a lawyer, they gotta come and go through all this.
I think we need some legislative work on this particular bill, maybe, with all these issues out there, and put some common sense in it, like
That's what I
Beverly
said, maybe we
said,
need some common sense.
and get this resolved, because all it's doing is making a lot of work for a lot of folks, and it's really not amounting to anything. You get down to the bottom, and you pull the cover back, and nothing there, but just a bunch of warts, no problem.
Chairman, may I ask Mr. Bill the same question, basically? What in this advisory opinion inhibits the prosecution by either a district attorney or the attorney general if they feel it should be prosecuted?
Well,
Because I think it says, I mean, our opinion is that's who should prosecute if it should be prosecuted.
yes, ma'am, I think there's as I mentioned last time, I think there's confusion between the word civil penalty and offense. It's kind of a intermingling of those two terms, which would, while a DA certainly would be able to proceed regardless of what, the Ethics Commission had issued as this advisory opinion, I think it makes it more difficult. I think it makes it more difficult for judges. I think it would make it more difficult. If I'm a defendant of that, I would hold this up. And I would say, well, no, the Ethics Commission has, quote, pardoned me. I get it, it doesn't use the word pardon, but that's gonna be a part of what a very savvy attorney, and we've got some great ones behind me, I'm sure, that would use that. So, they would certainly hold it up and say, look, I only have one offense, I don't have four. And so they would certainly rely on me.
But wouldn't that be the judgment of the trier of fact at that point? And that's who it needs to be in front of, is the trier of fact. That would be your circuit judge or wherever it would be filed, district judge, I don't know if it's misdemeanor.
Yes, ma'am, and I would argue that how many offenses, it certainly would be the trier of fact and wouldn't be, which is part of the reason we're asking for reconsideration of this. We would say it is up to the trier of fact to determine how many offenses.
Okay, we're gonna let, Ms. Cynthia respond on behalf of the Ethics Commission.
Yes, sir, and I think, to boil it down, what y'all decided is that the number of the offenses was also part of the term penalty that was used in the code, and that you could reduce that as well as the monetary fine. To address what Brent's talking about, and Andrew, to some extent, what Brent described is a situation that's come before this commission today, that the Secretary of State's office got a filing, and they looked back and believed that the expenditures in the previous months required and triggered the filing requirement. Well, that appeal came to us, and they had 5 offenses that they sent a letter to the Attorney General and the District Attorney that there was a rebuttable presumption that this person intended to violate the act. Upon further investigation, it turns out that the expenditures were simply for an accountant for the PAC, and that they had not made any expenditures with a view toward influencing the election. And so their fine, instead of $1,600, is actually $300. But what Brent is saying is that the Secretary of State is doing some fact-finding on their own, I think probably beyond the authority in finding out whether or not this expenditure is legitimately a view to influence election or not. But the fact-finding really should be done here. And to Andrew's point about a presumption of, like an habitual felony offender, you can use the prior offenses to increase a punishment, which we analogize to the rebuttal presumption of intent. But here there's no fact-finding for that, because the Secretary of State doesn't have discretion on imposing the fines. Somebody didn't file, they impose the fine, and then it comes to us to be the fact-finders to determine whether or not there was the intent present. And so, in the instant case here, the fine should only be $300, and I'll be asking the commission to reduce it to that because it was fined in error, but that letter went to the Attorney General and the District Attorney anyway. So that is, and also to Commissioner Brady's point, there is no limitation on prosecution from the DA or the AG, and as Andrew rightly pointed out, this is criminal and civil. We can penalize you civilly for this at the same time you're being prosecuted for it. So those are completely separate. Yeah, and we just decided, I mean, this commission decided that the number of the offense was a part of the penalty that we were permitted to reduce because it creates a rebuttable presumption of intent.
Okay, anything else?
Mr. Chairman,
Yeah, I just want to address something quickly. And that presentation is part of our confusion. So, Cynthia just said, the reason you can reduce the number of offenses is because it creates a rebuttable presumption of intent. But the rebuttable presumption of intent is only relevant to a criminal prosecution. So it seems, once again, it seems like although there's a disclaimer in this opinion that says it doesn't intend to prevent the Attorney General from prosecuting somebody, that is literally the whole point of what the opinion is suggesting. And that's exactly what she said, that the point of reducing the number of offenses or eliminating the offenses is to in some way pardon the person for committing the offense so that they cannot be prosecuted for committing the offense.
It does not say that. Excuse me, Mr. Chairman.
Go right ahead.
It doesn't, all it does is take away the presumption. You can still prosecute, you can still prove intent, but you got a job, you got to actually prove somebody had an intent.
Yes, sir, but the presumption is only relevant to a criminal prosecution, and that's our point, is this body doesn't have the authority to affect what happens within the context of a criminal prosecution. It just doesn't. It has the ability to reduce a fine to zero. It can write an opinion reducing the fine to zero that says this body finds that nothing wrong ever happened here, that these people did not intend to violate the law. It can give any explanation it wants to for reducing the fine to zero, but it cannot eliminate the offense such that when the Attorney General goes to prosecute, the Attorney General is limited to prosecuting for one offense instead of two. And that is the line. That is a clear line that we are asking this body to recognize, that the Attorney General and the DA, they're the authority that determine when a prosecution should take place, how many offenses that should be prosecuted, and then a circuit judge could obviously instruct the jury however they wanted to. They could grant a judgment of acquittal. That would be up to a circuit judge to make those calls and to determine whether this presumption should apply. But it's not this body's role to determine whether a presumption applies in a putative criminal prosecution. That the Attorney General and the DA have the authority to decide to initiate.
Okay, we're here on a motion to reconsider. What says the commission?
Judge, we do have the, Mr. Robichaud, who would.
Oh, okay.
If I may.
I didn't know you were
Sure,
going to be a part of
sorry.
this.
I'm Ryan Robichaud.
You
I'm the
caused all
attorney.
this trouble, didn't you?
I did, yeah, I
No,
apologize.
you didn't do it. I know you might have been some legislation to come.
But I request the opinion, I represent the Alabama Consumer Finance Association, ACFA. And we've got two high-level concerns here and why we request this. I mean, we're concerned about meaningful relief and checks and balances here, okay? You know, we've talked at length about what the civil, criminal, that kind of thing, but this body was clearly charged with the ability to oversee the civil process and to provide some form of relief. And the question is how much? Is it just a question of money, or is it number of offenses? Number of offenses clearly dictate, as Andrew said, I mean, it has meaning, both in the civil liability world, and I'm not going to get into criminal stuff, that's not my expertise, but it clearly has ramifications. And the legislature, I believe, intended to have this body be an overseer, appellate check on the Secretary of State's office, determining the number of offenses. And from what I'm hearing from here is there's no relief but for this opinion, okay? And there's no way for this body to say that's not an offense, whether it be because of good cause shown or a flat-out mistake by the Secretary of State's office. There's no true relief. If I come in here and I got assessed one violation, okay, one offense by Secretary of State's office, and it's clear a mistake was occurred, okay, no one disputes that you can reduce the fine. But the offense should go away too, because if I make a second mistake, a second violation, and that's not a mistake, it's being treated as a second, and I'm getting a higher level penalty, okay? At the fourth, I'm getting a letter of presumed criminal intent. And so if there's not a way for this body to eliminate offenses, I don't have full relief, I have partial relief, okay? And there's no check on the Secretary of State's office. So the question is, for this body, as I believe is, what do you believe the legislature intended when they had this system set up? Do they intend full meaningful relief? And do they intend this body to get checked? I believe they do, but it's your decision.
There is a Black's Dictionary that we all rely on to give us some advice about definitions of certain phrases, words set aside. I think Black Dictionary may have something in there that says set aside means to do away with. Maybe wrong. That's far-reaching definition. But anyway, would there be anything else? I'm gonna put this in front of the commission for.
Mr. Chairman, if I may add, just
Yeah.
real quickly, following up on Ms. Ralston had said as far as exceeding authority of reviewing our office routinely reviews maybe an amendment to a filing or those things where it shows that the person either just entered the information in an error or it was something where they just put it in unintentionally wrong. Maybe the $10 expenditure was really, they put in as $1,000, just type in a wrong button. We routinely review that, and if that information is presented to us, we do send them a new letter, and we do say, look, we admit that what further information you provided to us, and we've set that aside. So we believe we do have the authority to review that on additional information submitted to us, like an error or something where what they were presenting to us is not factually correct with what they actually did. So we routinely have done that, and we believe that we have the authority to do that in our office.
Okay, the matter before the commission is the motion to reconsider filed by the Attorney General and also the Secretary of State. What says the commission? I guess silence means that the motion to reconsider is a dead motion. So thank y'all very much for being here. I've learned a little bit today, and I hope we'll continue to work on this and get it, do what's right for the people.
If the legislature wants to change it, they can.
Okay, we have other matters to take up in new business, and the first matter is the requested advisory opinion by Mr. Michael R. Stewart, Deputy Director of the Department of Natural Resources. And I'll let one of you would be leading the.
That would be me, Judge.
Okay.
Yes, Judge, this employee of the city of Huntsville wants to go work for a private company that he had previously audited, investigated, or regulated. And after evaluating the dates that he regulated the company, we've determined that the specific date past that regulation he's permitted to go work for once that 2-year window has passed. So it essentially gives him the parameters of his employment, and that it would not violate the revolving door if he waited until after 2 years after he regulated.
Okay, do I have a motion with respect to this advisory opinion 218-14?
I would move we accept the advisory opinion.
Second.
Motion by Ms. Beverly and second by the judge. All in favor say aye. Aye. Anyone opposed? Passes 5-0. The next advisory opinion is the Honorable G.L.H. Lee, District Attorney for Shelby County, who is asking us for an opinion, and it is AONO point 2018-15. You speaking to that one too, I guess.
Yes, Judge. Jill Lee has a chief trial lawyer that wants to retire and come back and work part-time at the...
Trial prosecutor?
Yes, sir.
Okay.
He's an assistant district attorney, and he wants to come back and work for Shelby County after he retires as a retired state employee. And because we evaluated his position, and because he doesn't have any hiring and firing authority, purchasing or contracting authority to make decisions regarding influence of grants or rewards, and does not have that authority granted to him by Jill, then he's permitted to go back as a retired state employee on a part-time basis because he did not hold a position of authority at that office.
Okay, any questions from the commission? We have a motion with respect to this. I'll move. Second. Motion by Mr. Butch and second by Mr. John. All in favor say aye. Aye. Anyone opposed? Passes 5-0. The next advisory opinion is AO number 2018-16. Is Mr. Doug Key makes a request on behalf of the APCO Employees Credit Union, Birmingham, Alabama.
Yes, Judge, this is another revolving door opinion. Mr. UKG worked for the Credit Union Administration and regulated and audited the Alabama Power Credit Union while he was employed. His date of retirement was December 31st, 2016, and so this opinion just tells him that he can go and work for Alabama Power Credit Union after December 31st, 2018. He can solicit and accept employment after that date.
I move, accept.
Mr. Butch makes a motion to approve the advisory opinion. And second by Mr. John, and that is advisory opinion 2018-16. All in favor say aye. Aye. Passes 5-0. The next matter is an advisory opinion requested by Mr. Phil Williams, former state senator, who is in this advisory opinion number 2018-17. And John, Tom, you'll do that.
Yes, sir. Former Senator Phil Williams wants to go work for the Alabama Policy Institute. We have told him that since he is no longer a public official, he can certainly go work for them. The restriction that applies to former public officials, however, is that he cannot represent his new employer back before the legislature, the body of which he was a member, for a period of 2 years, and that would include any subcommittee of the legislature for the definition of the code.
The judge makes a motion to approve, and I
I'll
need
second.
second by Ms. Beverly. All in favor say aye. Aye. Anyone opposed? Is he here today? Okay. The next advisory opinion is an opinion requested by Mr. Preston Register. His number is 2018-18, and I think Mr. Register is attorney for the Houston County, Dothan, Alabama.
He is, Judge. And the request came because a sergeant with the Houston County Sheriff's Department was elected to serve on the county commission. And the question involves what involvement he can have with regard to the Sheriff's Department while he's on the commission. And our answer is that a county commissioner may vote on a matter concerning his public employer, provided neither he nor his family member is uniquely affected by the vote. This is consistent with previous advisory opinions as well as the opinion of the justices. A public employee who's a public official may use equipment, facilities, time, human labor, and other public property if the county commission and or the sheriff's department gives him permission to do that under their lawful employment agreement that's regulated by agency policy. And that he doesn't personally benefit from that use.
Any questions, gentlemen, ladies? Need a motion to? Someone, Mr.
Second.
John makes the motion and Ms. Beverly seconds. All in favor say aye. Aye. Anyone opposed? Passes 5-0. At this time, the commission will consider several appeals from fines which the Secretary of State's office has imposed under the Fair Campaign Practices Act. The Secretary of State's office is charged with assessing civil fines against any person who fails to timely file their campaign reports. Once that office imposes these fines, they may be appealed to the commission within 14 days. Upon a finding of good cause, the commission can reduce or set aside the civil penalty. On this issue, the person upon whom a civil penalty has been imposed bears the burden of proof. I again call on the staff to present these appeals in order, and we also have a representative from the Secretary of State's office here too, that the desire to make any comment on certainly can. But we heard a lot from you earlier, so maybe we minimize anything this go around. We have a lot to do on it. All right.
Yes, Judge.
Okay.
Henry County Republican Party, Mr. Singleton is their CPA, and he came on behalf of the party this morning, but we discussed it, and this is the one I was talking about, that upon further investigations after the fines were levied against the party, it was determined that the expenditures they made, if you're looking at your chart, in May, June, July, and August were all administrative expenditures. And so they were not made with a view toward influencing the outcome of an election. So the September 5th fine for not filing the September 5th report is the only one that should be imposed, and that is $300. And Mr. Singleton said it was their error and they will pay that. So if the commission could just vote to reduce the number of offenses down to 1, and that they will pay the $300 fine.
Okay, any
But
questions?
that's my recommendation.
All right, what says the commission? The
Second.
judge makes a motion to approve, and Beverly makes a motion to second. Now, that's to bring the number of offenses down to 1 and impose a fine of $300, okay? All in favor, say aye. Anyone opposed? Passes 5-0. Next one is Alabama Hospital Association. Pat.
Yes, and Mr. Greg Everett is here representing the Hospital Association.
Do you want to speak to it, or do you want to do that?
Well, they're asking
Oh,
for,
yeah.
you reduced the number of, the amount of the fine to 0 because you found it was an unintentional violation, and you wanted, and he is requesting that you remove that offense as well for this election cycle.
But come on up, Mr. Gray. So this is a little bit different what would the other is. Would you explain what you are asking this commission?
Yes, sir. My name's Greg Everett. I'm an attorney here in town, and I represent the Alabama Hospital Association Political Action Committee. I have represented this particular association for 25 years. My joke is I went from in-house to out-house counsel for the association. So I have a long familiarity with them. I won't belabor what I was prepared to talk about with y'all on your opinion earlier that you've made about your authority to reduce or set aside a penalty. Y'all have decided, I think, pretty clearly that you have the authority to do that, and we're asking that you exercise that authority in this particular situation. What we had was back in the January filing, which was due in February, it was due February 2nd, was not filed till February 9th. And the reason the filing date was missed was the individual who was responsible for filing that when the Secretary of State had been in the hospital, was operated on, and came back to work, but was only part-time, was having to go get physical therapy and some other stuff. Anyway, once they realized they had missed the filing date by a week, they filed and have not missed any filing date since that time. So we ask that you use your authority to set it aside for good cause. Good cause would be, we think, someone being ill, missing a filing by a week, and furthermore, there's this Political Action Committee has a good record, if you will. It was created in 1983, and to my knowledge, they've never had an issue before this commission or anyone else with missing anything or a violation of any law. So we ask that the commission use your authority, as you discussed earlier today, to set aside that one penalty.
Okay. Chris, you have any questions? All right, what says commission?
I'll move to set it aside.
Motion to.
1 week late
Yes, sir.
and no other violation.
No, sir.
Mr. Butch makes the motion and the judge seconds. And the motion is to set aside the convictions against, the imposition of the fines against the Alabama Hospital Association Bank. All in favor say aye. Aye. No opposed, passes 5-0.
Thank you.
Next one is Barbara Drummond.
Yes, Judge. Is Ms. Drummond here? No. All right, she thought the campaign disclosure had been filed prior to the deadline. Once the system sent her an unfiled notice, she did file, but it was a day late due to a technical problem. She mistakenly missed clicking one button on filing her disclosure at the proper date. She has had three fines set aside previous to this.
So we're talking about the October 4, 2018?
Yes, sir, that's all. We just left the other ones on there for your for you to have that information. But yeah, she filed, the report was due on October 2nd. She filed on October 3rd.
And we had set aside 3 prior ones.
Yes, sir.
Okay, what says commission? Can we boil down to no action taken, or if we decide to set aside, then that would be?
I move that we deny my request on the grounds that she had previous ones set aside at different dates and different times. That lapsed between
Where she's,
April and October.
or was that, she's had her chance, and we helped her, and.
I'll second that.
Okay, the judge makes a motion to take no action, and Mr. Butch seconds that. All in favor, say aye. Aye. Passes 5-0. Etowah County Democrat Women's Club.
Yes, yes, Judge. We have somebody speak for them.
How you doing?
I'm good, nervous.
You,
These people are way over me. I'm Susan Copeland from the Etowah County Democratic Women's Club, and we are here today to ask for an appeal. I wrote a letter. I don't know if y'all have a copy of that letter that I wrote. They have fined us because we were not a PAC, had no knowledge really that we needed to be a PAC. We are a group of women that just love and care about our community, and we have in recent years brought men into the group, but we were very unaware that we even needed to be a PAC. So then we got a fine of $300 that went back to August the 2nd. The first day I was aware, you can tell from my letter, the first call I got was on September the 7th, and really floored me because I'm just, I'm not a real knowledgeable person about all these things, but I was taken back by it. I had to find out even what a PAC was. We had no idea that our Democratic Women's Club should be a PAC, and so I got back with my board. We decided it was something we needed to do, which in the long run may be a good thing because it makes us feel like it, it makes something proud for us. But at the same time, the fine went back to August the 2nd, and we were not even a PAC at that time. So my appeal is that y'all would set aside the fine because we were not actually a PAC at that time and were unaware that we needed to be one. So we on September the 12th filed to become a PAC, and from that point we've been filing every week during the campaign. So we would ask the commission to set aside that fine of $300 since we were not aware that we even needed to be a PAC at that time on August the 2nd, and we're not a PAC for that reason.
any questions, commission? What does the commission want to do?
Mr. Chairman, I move we grant the appeal.
Okay, we have a motion by Mr. John to, for good cause shown, to grant the request to set aside, and seconded by Mr. Butch over here. I think the judge did too, but all in favor say aye. Anyone opposed? Okay, it is done.
Judge, are you setting something fine and the offense both?
Yeah,
Okay.
so, good call shown.
What's your
Thank you very
ratio now, women to men?
Too many men.
That's what I heard somebody say to Congress the other day.
I wouldn't really want to guess that, but
Thank you,
there
ma'am.
are still more women, I will say that. Thank you so very, very much.
Lawrence County Republican Party.
Is anybody here for the party? Okay. The judge,
Wait.
okay.
Susan Copeland. Yeah, that's the one we did, wasn't it?
Yes, sir. Flip, on the next page is Lawrence County.
Yeah, that's all together, I think. Lawrence County Republican Party.
Yes, sir. They are unable to be here because the treasurer is a police officer and works he's a narcotics officer and works all the time and was unable to be here. And he did not know that he had to select the election cycle under the filing section. And by the time they realized that they had not done that, the time of filing was March 1st, it was past the first date for the filing. This was the first time to file during an election cycle, and they had only previously filed the annual report because they got caught up in the change of the law. And he says this is an honest mistake, but he's requesting that the fine and the offense be reduced.
So it's filed like, less than a month late, is that right?
Yes, sir. It's filed on March 1st, and it was due on February 2nd.
What says the commission?
I move that we grant the appeal for good cause shown.
Second.
Mr. Beverly, Grant, makes the motion, and Mr. John seconds. All in favor say aye.
Aye.
I guess that's equal rights. We just did the Democrats, and now we're doing the Republicans.
And Mr. Kenneth I'm sorry, Judge.
Kenneth Sharon Robinson Sr.
Yes, sir. And Mr. Robinson is here.
Come on up, please.
Good morning.
Good morning.
My name is Kenneth Robinson from Houston County, and I come before this commission actually to set aside the lateness I filed, but I had problems with the computer file. And it either sent me to a voicemail or I could never get it up online. And every time I got it up online, I either be out to midnight or trying to stay up all day trying to get it right, filing and get a new password and things of that nature. So I'm asking this commission if it would consider my ignorance, trying to work with their computer and making sure I get everything in there on time. When I did have a penalty, I came up here to Montgomery and paid whatever penalties and fines that I had. And this last time I got ready to file, I was late because of that computer error. And I could never get nothing done through that system. And I finally got someone on the phone. They had to walk me through the system. And it was like a day late or something like that.
So you're asking commission to set aside the second, third, fourth, and fifth, and sixth. Does it show any fines being imposed?
There's not. He's just asking for the number of offenses too.
Okay, I understand.
See, at first I had someone working for me to file, and then after they couldn't work for me anymore, I had to do it myself, and that's when I ran into the problem of trying to get it on time.
You paid the first fine.
Oh, yes.
Okay. And you're asking that the rest of the cases, I guess, are be set aside. Is that what you're asking for?
Yes, it is. It wasn't a day or two, just a couple of.
Okay, what says commission?
What is your position? Are you filing for yourself or for someone else?
For myself, yes, sir.
You're a candidate?
Yeah, I ran for sheriff in Houston County.
Did you win? You have no further reporting going on?
No further reporting. I came, I came in a good sample.
I move that we grant
And we have any evidence that these representations are not true, that these, I'm older than you, I have trouble with my computer too. That these representations are correct. We have any reason to believe that it's just a...
No, I think that he did have to get a new password and he did have to get set up in the system.
Yeah,
And none of the fines that are before you being appealed today does the Secretary of State believe that there was any
Okay,
intent
I
to
second
file.
the motion.
Judge makes a motion and Mr. Butch seconds. And the motion is relative to all the, let's see, April 2nd, let's see, the
second, third, fourth, fifth.
second, third, fourth, fifth, and sixth alleged violation to be set aside. All in favor say aye. Aye. Anyone opposed? Passes 5-0.
Thank you very much.
You're lucky in a lot of ways. You got help. helped today, but the main thing, you didn't win that sheriff's race. Man, that'd be a challenge.
Yeah.
Okay, Malika Fortier.
Is Ms. Fortier here? All right. She was fined and paid a $300 fine previously. The only appeal that you can consider today was the one for the October 2nd report that was not filed until October 3rd. She says she was only a little late after 12 a.m. deadline because of computer problems, and she is asking for forgiveness for that third offense.
When you said, she said a little late, how late was it?
It was in the middle of the night, I think.
One day,
It was, well, yes, it was hours. She filed after midnight.
What says commission?
What, hang on, I'm sorry.
Mr. Chairman, Commissioner, this is the third time this has happened. So you asked if this was just one time. This is 3 separate occasions with 3 separate date ranges.
one day she was a day late, one day she was 3 days late, and one day she was just hours late, right?
Yes, sir. Correct.
And she paid $300 originally. So she did suffer some consequence. So,
Yes, and she, Judge, the 469.50 that you see there, she is not able to appeal that because that was outside the 14-day window. So she has to pay that
So
fine.
you only feeling, you only applying for forgiveness on October 4th.
Which was less than a day late.
Yes.
I move we set aside.
second. Mr. Butch makes a motion, Mr. John seconds. And that is relative to setting aside October
Just the board.
The fine and the offense?
on October 3rd, fine and what?
And the offense?
Yes.
Just need to clarify.
Okay, all in favor say aye. Anyone opposed? Passes 5-0. Tuscaloosa firefighters public relations fund.
Yes, Judge. So, they are appealing the fine for the October 15th filing. It was due on October 15th, they filed on October 16th. And he says that he uploaded a file at 8:29 p.m. and thought he had filed the report at that time. He received an email at 3:31 a.m. saying it had not been filed, and he immediately relogged in and filed that report as soon as he got the notice. And he apologized for the lateness and will try to receive, I don't know what receive means, but he will try to observe the deadline on the other reports leading up to the general election.
So the only thing he's asking for relief on is the October 17th,
Yes, Judge, that's the only thing he could receive relief on, yes.
and he filed on,
One day late.
1 day late.
Yes, he was previously forgiven for his 5th offense that was filed 1 day late on, you heard that on September 5th. At the September 5th meeting, you forgave a fine of $1,200 at the September 5th meeting.
I'll make the motion.
I second.
Mr. John makes a motion and Mr. Butch seconds, and that is to set aside the fine in the case of October 17, 2018. All in favor say aye. Anyone opposed? Pass 5-0.
Is that, and that's the fine and the offense, Judge? Okay. That is the 6th fine and offense. There's nothing else we can.
Motion to reconsider, we have one here that's, are we ready to take that motion up, Ms. Andrews?
Yes, Judge, we are. I would like to provide you with something before Mr. Gosnell is here on behalf of Stacey Green. We had originally there was, actually, never mind. You consider the motion reconsider, and I'll give you this later if you need it. Because that's factual.
Yes, sir. Would you state your name into the record and tell us who
Yes,
you
Mr.
represent and
Yes,
go ahead
Mr. Chairman, I'm sorry. My name is Scott Gosnell. I'm an attorney in Birmingham. I represent the respondent in this particular case. And we are asking this commission to reconsider their previous decision in this basically on two grounds. The first is that my client received her notice of the first hearing where y'all made a determination on the day of the hearing. The certified letter notice was in her mailbox
on that day. She had no opportunity to then make arrangements and actually be here at that hearing. The second grounds for the reconsideration is that some of the evidence that this commission considered in that case was a little inaccurate, was in error, and we would like to correct that and then have this commission reconsider their determination based on the accurate evidence. And I'm not sure, but I believe Ms. Ralston may have
I have a sheet.
then provided that to you.
The first thing that you brought up is, to me, is the most important, and that is the notice, whether or not we actually notified her appropriately before, so she could come down and present her side of the case. Now, what is the status of that?
Judge, for the, I'm sorry, just one second. That letter was sent on July 20th for the August 1st meeting. My information from Mr. Gosnell when he first contacted me about this was that she was out of town for 2 weeks and did not receive the letter. And obviously our staff can't be responsible for that, but she did know that she had, and I don't, we're in public session, so I don't want to say too much, but she was aware, obviously, of the complaint filed against her, and she was aware of when the hearing could be, the optional dates for the hearing, so.
Well, aren't we required to give more notice than that?
No, sir. We are not required to give notice of the hearing statutorily at all. We're required to give 45-day notices to the respondents that a complaint has been filed against them.
Okay, I knew there was a requirement of some sort.
Yes, sir. And there's no statutory requirement for notice, but all of the notice that we send satisfies sort of the civil requirements for notice about regular mail or certified mail, and we did send that certified mail.
So you're saying you don't have to notify?
We do.
About statute?
Yes, sir. No, but we do. He was just asking what our obligation is. I was just talking about our statutory obligation for notice is regarding the 45 days for that a complaint is pending against someone. We obviously notice every respondent about the
But
hearing.
the day of the hearing, you're not obligated to send notice on the day of the hearing?
Not statutorily.
Really?
No, sir.
So you come in and have a hearing on a complaint against someone without
Yes.
giving a notice legally?
Correct. According to our statute, I think there's other reasons why we
You get that changed then. I mean, everybody decide, should have a notice of when you're gonna
Yes.
take some punitive action against them.
Well,
I know you do it, but you're saying legally you don't have to.
correct.
Well, I mean, you know, in some, in the law should be that you have to.
Well, yes, sir, but we function as a grand jury, and there's no, yeah, so, yes, sir. We give notice to every respondent all the time.
I know you do.
I just
but
want to
you're
make that
saying legally
clear.
You don't have to. Even a grand jury, you give a notice when you have to appear.
Yes, sir.
I believe that we set aside and set another date for the hearing.
Well,
We always like to have hearings around this place, you know that.
well, I would,
We have a motion.
yes, Judge, she wasn't represented by counsel at the time when she got the notice, and she chose not to come even though she had the notice. And this is an awkward, the reconsideration is an awkward discussion because there are facts that I would like to present to the commission that I don't think that I've been permitted to do in the public session.
Well, I'm just talking about, you know, opportunity to come and be here when you do permit.
Yes, sir. She knew that she had a complaint pending against her, and she had talked to our agent, and
Having a complaint, knowledge of having a complaint lodged against you is one thing. Being able to be notified and have accurate notice of the day of the hearing, present evidence against you is another thing.
Sure.
Now, although you sent the letter out within time, she was out of town, many people were out of town. And she get the letter upon her return on the day of the hearing. Well, it's only fair that we set this for another hearing date, and let her come in and you present everything.
well, we can present that today in executive session. We don't have to wait another hearing date.
Mr. Chairman, Judge, if I may, just to make it clear, there's no question that she, my client did have notice, 45 days notice that a complaint had been lodged against her. That is no question. She did, the question is, did she have notice of the actual date of the hearing? And that she didn't get until the date of the hearing in Birmingham. So it's not quite accurate. She was not represented on that day and didn't choose to not show up. She couldn't show up because she didn't have notice at that time. As soon as she received that notice, that's when my office got the telephone call, and we asked for for a reconsideration, and we are actually prepared to do that today if this commission so chooses.
Is that something that the commission wants to go ahead and allow for? I mean, we ought to have all the parties here, and we have, the commission has their witnesses and evidence and stuff. Why don't we
Judge,
just-
I move that if that is the request of the respondent, that is what we do
All right,
here today.
motion was made to reconsider and have a hearing, and,
I mean,
Judge,
Brandon.
you seconded, and Judge made, or, no, you made a motion.
I mean,
That's right. She seconded. All in favor, say aye. All right, now hang around.
Thank you.
But don't go too far.
No, sir.
Okay, let's see.
I'm sorry, Judge, where are we?
We are in, we're just sitting right here, right now.
That's great. We are in the public service.
You out there, we up here. We are now at, let me make a little note here before I get it on that last case. Okay, ladies and gentlemen, we are now going into what's called the executive session. I told you in the beginning what that was all about. We'll be discussing matters relating to the character and reputation of certain public officials or employees, as well as matters covered by the Grand Jury Secrecy Act. No matters will be discussed which are outside the scope of the state guidelines for the holding of executive sessions. We expect to reconvene in a reasonable length of time. I don't want to put a time specifically on it because it could be a long time or it could be a short time. So this, if you got matters to take up here at this facility today, don't leave. Any members of the press who have tripods in the hearing room, and I don't think we have any. If we do, you can leave them in there, but you got to cut it off. Any secret recording of the executive session will be a violation of the law. They have a motion to go into executive session.
So moved.
The judge makes a motion. Do I have a second?
Second.
Ms. Beverly makes a second. All in favor say aye. Vote is 5-0. And now we will move into executive session after we have a little bathroom break. Hey. Definitely. Butch. All right, me too.
I know it doesn't matter. We'll talk to them. I know.
You can't reconsider something that's already in.
Doing better.